Hello, I'm Morgan Bowen, a senior associate in the restructuring and insolvency department of Mills and Reeve, based at their London office. I am one of the course directors for the R3 Directors' Duties series, and it is my pleasure and honor to be introducing your speaker for the third part of the five-part series. You have already heard from Joanna Ford in part one on advising directors pre-insolvency, and from Jamie Leader in part two, which looked at office holders' claims against directors from the office holders' perspective. In this part three, Andy Taylor will be looking at office holders' claims against directors from the director's perspective. This talk is designed to give you an insight into how directors should respond to claims made against them, and some guidance on how their legal advisors should advise them. Andy Taylor is a director at solicitors Isadore Goldman, who specialize in insolvency. Andy Taylor joined Isadore Goldman in London in 2014, following a 25-year career at Southeast firm ASB Law, where he created and led the insolvency team. Both Andy and the team were recognized in Legal 500 and Chambers as leaders in the field of insolvency law. Andy has also been recognized by the Lawyer as one of the Hot 100 lawyers in the UK. For many years, Andy's main area of practice has focused on advising directors of companies experiencing financial problems or which have gone into administration or liquidation. His clients are typically under great stress and require pragmatic advice to get them through a very difficult period in their lives. This is where Andy excels. He is renowned for his skills in analyzing a situation, identifying the problems and priorities, and helping clients to create and implement an action plan. His notable achievements include conducting the investigation into failed FTSE 100 company Finalist PLC, which resulted in the disqualification of 4 of its main board directors. He is regularly involved helping directors deal with demands for information from office holders in the insolvency service, assisting them in any interviews and investigations, and dealing with any civil recovery or disqualification proceedings brought against them. His talk today has a particular emphasis on costs issues. This is often the key consideration in legal proceedings of this type, where you have an insolvent claimant and a defendant who is an individual. It is also notable in this regard that Andy is head of Isadore Goldman's CFA committee, which decides which cases the firm is prepared to take on under conditional fee terms. And he is expert in these types of cost and benefit considerations. When/if to settle, the other side's likely appetite for the fight, the other side's likely minimum settlement amount, and how that might change over the course of the litigation, etc. As course director of this part of the series, I cannot think of a better person than Andy to deliver this talk. And so without further ado, I will hand over the floor to Andy. Thank you.
Thank you so much for that kind introduction and for asking me to present this part of the series. I make no apologies for the fact that a considerable part of my talk looks at claims from a cost-benefit perspective. After all, the liquidator's purpose in pursuing the claim is to recover monies for creditors, and it's often said that creditors would prefer to receive £1 today than the uncertain prospect of £10 sometime in the future. Creditors generally, and HMRC in particular, are unimpressed if the recovery from a claim is consumed in the liquidator's costs of pursuing the claim. Conversely, most directors have limited resources, and the most valuable asset is likely to be their home. I pose the simple question: if you were the director, how far would you go to defend your home and family life? My talk today explores the following areas. Can the director afford to pay defence costs? The importance of carrying out a cost-benefit analysis at the start of the retainer, which solicitors are professionally obliged to do. Taking advantage where the liquidator is contemplating a claim that has to be brought under the standard CPR Part 7 claims procedure, such as a claim under Section 423 of the Insolvency Act. Next, how the defence strategy changes according to how the costs of bringing the claim are dealt with. Then exploiting what the liquidator does not know, identifying the limited situations where the onus of proof shifts to the director, and then explaining why the liquidator's habit of overcomplicating claims undermines the prospects of settlement and recovery for creditors. I then conclude this talk by identifying some of the steps I would advise Freya and Frank to take if claims are made against them. So, moving to the question, can the director afford to pay defence costs? Now that Freya's company has gone into liquidation, she has not only lost the business, but also the income from and access to cash associated with it. Probably is having to deal with the consequences of personal guarantee claims, and the case study contemplates she's facing investigation and claims by the liquidator. This constrains her ability to pay for legal advice, let alone to defend claims by the liquidator. For directors with other business interests, one common issue is that they want the costs of funding legal advice to be paid for by the business. But most liquidator claims are against the director personally. For a solicitor, the first problem is that you can only bill a client. Depending on the circumstances, it may be appropriate for the business to be a joint client with the director, or alternatively, you might obtain confirmation that the business is lending the monies to the director to pay the costs. What you must not do is bill the business without sorting the retainer out, as this can lead to various types of risk, including the risk of having to pay the monies back if the business fails, or at worst being caught up in any investigation by HMRC into tax evasion. A common problem for the solicitor is that the bill is raised to the director, but it is paid by the business without the solicitor realising. The SRA is putting increased emphasis on the need for a solicitor to carry out a risk assessment at the start of a retainer, which would include asking the director to confirm the source of payment of the solicitor's costs. Solicitors are obliged to advise clients to check if they have insurance or other arrangements that will cover legal costs. The obligation is not just to mention this, but also helping them to identify such sources of funding. For example, a director appointed by a shareholder under the terms of a shareholders' agreement might have an indemnity from the shareholder. The company may have had directors' and officers' liability insurance cover in place. Such policies are claims-based, meaning the claim has to be made during the policy period. Usually, a liquidator's investigations do not get underway until sometime after liquidation, by which time the policy period has expired and it's too late to make a claim. A further difficulty for the director is that the policy is incepted by the company for the benefit of directors, and it is the company that must make the claim. Both the director and the liquidator ought to consider notifying the insurer of a potential claim within the policy period. Whilst the insurer is likely to initially reject this as not being a valid claim under the policy, there is nothing to lose. It might seem counterintuitive for the liquidator to initiate a claim on the policy for the director's benefit, but this can make a claim financially viable if the insurer has to pay the claim. It is therefore important that the liquidator identifies upon appointment whether there is D&O cover in place. That deals with the matter of retainer. Now moving on to the cost-benefit analysis. Solicitors are required to give clients advice about the likely overall cost of a matter and expected to undertake a cost-benefit analysis. This is particularly relevant when a liquidator makes inquiries of the director as part of the investigation process and during pre-action dialogue, because the costs incurred by the director in responding are unlikely to be recoverable unless proceedings are taken and successfully defended. For example, if the director is going to incur significant costs during these phases but could settle for a similar sum, then it makes more sense to settle. A typical cost-benefit analysis flows from answering three questions. Question 1, what is the situation facing the director? Question 2, what does the director want to realistically achieve? Question 3, what can be done to achieve the director's objective? During the pre-action phase, the director needs to consider not only the strength of the liquidator's claims, but also the overall implications to the director of becoming involved in defending court proceedings. Defending proceedings will require a considerable time commitment by the director and the required resolve to help gather and provide the information and documents that the solicitor needs. If the director has other business interests, then these can be adversely impacted as a result of the director being distracted. Whilst there are some directors who thrive on being involved in disputes, most find the experience very stressful and alien. This stress will usually extend to their families. In most cases I deal with, the starting point is that the director is aggrieved that the liquidator is threatening a claim, particularly where the director was introduced to the liquidator as someone who would take care of putting the company into liquidation. This is aggravated where the claim is in relation to unlawful dividends or an overdrawn director's loan account, where the director routinely says advice should have been given by the insolvency practitioner before the decision to put the company into liquidation was made. One practical way to resolve a claim is for the director to show the liquidator that even if the liquidator succeeds on the claim at trial, the director is not going to be in a financial position to pay enough to cover the liquidator's costs, making the pursuit of the claim uneconomic and undermining the purpose of bringing the claim. This is slightly different from the question as to whether the director is worth suing because it brings into play timing issues. For example, the case study does not tell us anything about Freya's financial circumstances, but let us assume her assets are a £200,000 interest in a jointly owned family home, £50,000 of savings, a small personal pension, which she cannot draw down until she is 55, and shares in another company she owns, the connected company, which are of little realisable value. The liquidator might have claims worth £1 million or more, but the value of that claim is academic in circumstances where recovery is by reference to Freya's ability to pay. The liquidator might consider Freya is worth pursuing because she has net assets of perhaps £250,000. But this ignores the fact that the only way Freya could pay £250,000 is if she and her partner agree to a voluntary sale of her home or raise a secured loan on it. This is unlikely to happen for a variety of reasons, including the problems associated with trying to remortgage or to buy an alternative home. Let us assume the liquidator settles the claim without proceedings for a payment of £80,000 cash, funded from the savings, and £30,000 from Freya's family. This settlement should result in a full recovery of the liquidator's costs, that means legal costs and the liquidator's remuneration, of asserting the claim, and there will be monies available to distribute to creditors. This might then be contrasted with a position where the liquidator is a year into taking proceedings, has incurred costs of, say, £60,000 with solicitors and counsel, and the claim is at the position where it is listed for trial. Freya's savings of £50,000 have been spent on defence costs and living expenses. The family may also have provided funds to defend the proceedings, but on the basis of security over Freya's interest in the family home. If the claim is pursued to trial at additional legal costs of £40,000 and there is an ATE premium of £20,000 to be paid if the liquidator wins, the claim is unlikely to ever result in a return to creditors, especially once you factor in the liquidator's own time costs and any success uplift due on the lawyer's fees. Also, getting judgment doesn't mean getting paid. Making Freya bankrupt after judgment simply makes it less likely that monies will be recovered by way of a dividend from her estate, and any dividend is unlikely to be received for at least 2 years. What this means in practice is that there frequently comes a point in the claim where both the liquidator and the lawyers acting for the liquidator realise that they're investing time pursuing a claim for which there is no realistic prospect of them getting paid for future work. The corresponding problem for the director, in this case Freya, is that the claim is now incapable of settlement unless the liquidator and lawyers decide they want to bail out by negotiating a drop-hand settlement, or are otherwise prepared to settle on the basis of a contribution to costs only. Many solicitors advise the director that the best time to mediate is after evidence in answer has been served and when both sides can assess the strengths and weaknesses of their respective positions. I disagree, especially with low-value claims or where the director's resources are limited. An assessment has to be made with the director whether the purpose behind serving evidence, with all the attendant cost, is because the director intends to defend the claim to the point the liquidator withdraws or loses at trial, Or is it to create a platform for settlement? If the latter, then cost-benefit advice should explore whether the costs of preparing evidence would be better spent on settling, freeing up the director from all the stress and inconvenience of preparing evidence. The dynamics of defending a claim will change if the liquidator makes an early Part 36 offer or a call-to-bank offer to settle at a very realistic level, which gives the director a real choice between defending or settling. A director can be reluctant to open settlement dialogue in case it implies weakness in the defence. Receipt of an offer from the liquidator overcomes this. I now move on to the problems of Part 7 claims. If the liquidator can bring a claim under the Insolvency Act using the summary procedure, then the court fee payable is £280 currently. But if the liquidator has to bring proceedings under Part 7 of the CPR, the liquidator has to pay a court fee based on 5% of the claim value, capped at £10,000 if the claim value exceeds £200,000, together with various other court fees as the claim progresses. This can be a problem if there are insufficient funds in the liquidation. At the time of giving this talk, the government has just announced that the extension of fixed recoverable costs will apply to all claims brought under Part 7 of the Civil Procedure Rules. This will come into effect from the 1st of October 2023. A new intermediate track is being introduced, which means that civil claims with a value of between £25,000 and £100,000 will be subject to fixed recoverable costs. This may limit the amount of costs the liquidator can recover on Part 7 claims issued after the 1st of October 2023. The main objective behind the regime is to promote the resolution of disputes without resorting to the courts. Perhaps this is a different way of saying, by not making it attractive to claimants in terms of recovering costs, they are more likely to settle. With a Part 7 claim brought in the name of the company, the liquidator can also be required to give security for the defendant's costs. In the decision Absolute Living Limited against DS7 Limited from 2018, the court exercised its discretion not to require security on the basis that the claim would otherwise be stifled. But this decision cuts across the general run of legal authority that says security should be given. For example, in Meadowside Building Development Limited against 12 to 18 Hill Street Management Company in 2019, it was considered that security may be provided by a liquidator through an undertaking by the liquidator, a third party providing a guarantee or bond, or ATE insurance. But on the facts of the case, the court decided that particular ATE arrangements did not provide adequate security. So taking those three things together, the court fee, the fixed recoverable costs, and security for costs, these can provide three barriers to a liquidator issuing proceedings using the Part 7 procedure, and by the same token gives a director the opportunity to settle a claim. The next consideration is how the costs of bringing the claim are being funded. It is relatively unusual for the liquidator to pay lawyers to bring proceedings. This is primarily because there are insufficient liquid funds in the estate to pay the costs, but there are two other main reasons. Firstly, under SIP 2, if the liquidator is going to spend estate funds on bringing proceedings, thereby denuding the pot of money available to distribute to creditors, the liquidator is supposed to consult with creditors. This can be difficult, especially if there's no creditors committee. But even where there is a committee, getting buy-in from the creditors can be difficult, unless they can be shown the prospect of a significant increase in dividend prospects and that embarking on litigation won't delay matters. Secondly, if the liquidator wants to incept adverse cost insurance, the insurers usually will want the lawyers to be sharing in the risk of bringing the proceedings. From the director's perspective, if a claim is being paid for out of liquidation funds, then the director will know that the minimum return the liquidator will want to make is the amount required to recover the costs, and the liquidator will be inflexible about this when discussing settlement. Paying the costs as the litigation progresses imposes a discipline that is absent from CFA retainers. the director will know that if the liquidator is funding the progression of the claim, then the liquidator is paying more attention to the claim. The problem with claims brought under a CFA is that the arrangement can work well if the claim is settled early, but otherwise can run into difficulty because the costs, including success uplift and AT premium, quickly become disproportionate to the prospects of recovery. The problem with claims brought under a CFA is that the arrangement can work well if the claim is settled early, but otherwise can run into difficulty because the costs, including success uplift and ATE premium, quickly become disproportionate to the prospects of recovery. The problems can be exacerbated where HMRC is a significant creditor and expects the proceedings will result in a return for creditors, so that, irrespective of the terms of the CFA, the liquidator tells the lawyers that the so-called insolvency understanding applies, and any monies recovered must be divided three ways, being something for the lawyers, something towards the liquidator's time costs, and something for the creditors. At that point, the liquidator and the legal team can start to lose interest in progressing the claim. The lack of focus can then have knock-on effects in terms of inadequate case preparation. And a common feature is that steps in the proceedings are taken at the last moment. An astute solicitor advising a director will notice the change in behaviours and will be able to take advantage. Whether funding agreements produce the most cost-effective return to the liquidator is beyond this talk, but with funded claims, the director knows that the claim will be pursued in a disciplined and organised way, and that the funder has assessed the merits of the claim before agreeing to fund. The lawyers are being paid to progress the claim, but at the same time, the costs are controlled. Together, this makes it far more likely that the claim will be pursued to trial if the director does not settle, in addition to which funders are more astute in making Part 36 offers at realistic levels, which puts pressure on the director to settle. On the other hand, these same factors can make it easier to have sensible settlement discussions. If the liquidator is minded to settle the claim to a litigation funder, then the liquidator is obliged to give the director the opportunity to buy the claim. In that regard, I would refer you to the Insolvency Service Technical Manual, paragraphs 37, and also the case of Hamilton against Official Receiver from 2002. Of course, if the director buys the claim, then it's extinguished. So an opportunity to buy the claim is an opportunity to settle, which should be afforded to the director before the claim is sold. I next move on to the exploitation of what the liquidator does not know. And I start by looking at the liquidator's position and evidence from the liquidator. There is no magic about a claim by a liquidator against a director. If a claim goes to trial, then the judge will decide what happened, identify the appropriate law, and apply the law to the facts to make a decision. The factual analysis is based on the judge's consideration of the evidence. The courts have frequently expressed their preference to rely on contemporaneous documents rather than on the testimony of witnesses. Nowadays, the use of emails and text messaging means that there can be a wealth of contemporaneous communications available. The liquidator's difficulty is usually in getting access to those communications, a subject which is beyond the scope of this talk. The liquidator is not a witness of fact, save for any interaction the liquidator may have had with a company or its directors prior to liquidation or post-liquidation when making inquiries. From around 2018, the courts have noticeably become irritated with witness statements prepared by lawyers for liquidators to sign, which provide commentary on documents, give opinions, and make arguments. As an example, in the case of regarding care homes in 2018, ICC Judge Barber directed on the first day of trial that a witness statement from the liquidator should be excluded from evidence. The judge said, "It is not, for example, the function of a witness statement to provide a commentary on the documents in the trial bundle, nor to set out quotations from such documents, nor to engage in matters of argument, expressions of opinion, or submissions about the issues, nor to make observations about the evidence of other witnesses. Paragraph 19.4 of the Chancery Guide goes on to confirm the long-standing principle that witness statements must indicate which of the statements made are made from the witness's own knowledge and which are made on information and belief, giving the source of the information or basis for the belief. As a general rule, the witness should identify by name any such source. The liquidator's statement breaches each of these guidelines. It sets out at length the liquidator's own interpretation of documents. Such interpretation is a matter of opinion only and is of no real probative value. It also contains factual assertions for which no source of knowledge is provided. This is unhelpful. Fed up with witness statements being crafted by lawyers, in February 2021, the Business and Property Courts introduced Practice Direction 57AC, which overhauled the rules relating to the preparation of witness statements. The key features of the new rules are that witness statements must be in the witness's own words and should be used where it is necessary to prove a point of fact that is in dispute. And the new rules also say that witness statements should only contain evidence as to matters of fact of which the witness has personal knowledge. In addition to the normal statement of truth, the witness statement has to contain the following words. I understand that the purpose of this witness statement is to set out matters of fact of which I have personal knowledge. I understand that it is not my function to argue the case, either generally or on particular points, or to take the court through the documents in the case. This witness statement sets out only my personal knowledge and recollection in my own words. On points that I understand to be important in the case, I have stated honestly how well I recall matters and whether my memory has been refreshed by considering documents, if so, how and when. I have not been asked or encouraged by anyone to include in this statement anything that is not my own account, to the best of my ability and recollection, of events I witnessed or matters of which I have personal knowledge. The statement has to be endorsed with a certificate of compliance signed by the relevant legal representative. And the appendix to Practice Direction 57AC sets out the procedure that must be followed when creating a witness statement. Practice Direction 57AC says that the rules on witness statements only apply to evidence to be given at trial. In other words, they don't apply to interim applications. And it also says that it does not apply to an application for an order under the Insolvency Act 1986, meaning it does not apply to proceedings taken by the liquidator under the summary procedure. However, the court has an inherent power to apply the practice direction, and if the summary procedure has been used, but the court has directed the case to be pleaded, then the practice direction will almost certainly be applied. In addition to the liquidator giving evidence, there are other sources of evidence. Whilst the liquidator has strong powers of investigation, particularly as regards directors under Section 235 Insolvency Act 1986, it is quite remarkable how inadequately those powers are used before claims are advanced. Once claims are advanced, the powers are curtailed. Historically, directors were interviewed in person with notes being taken, and recalcitrant directors were forced to be examined at court at enormous cost. But nowadays, remote interviews by Zoom or Teams are simple to arrange, can be recorded at a press of a button, and can generate evidence that is difficult for the director to resolve from later. Conversely, the lack of such interviews can be exploited when defending a claim. Having said this, the 2021 Court of Appeal decision in Al Jaber against Mitchell means the liquidator needs to follow the correct process in gathering information from the director, whether by correspondence or an interview. Otherwise, it may not be admissible in subsequent proceedings against the director. The liquidator will struggle to get other witnesses to give formal witness statements, especially having regard to the requirements of Practice Direction 57AC. It is one thing for creditors to be unhappy at what the director has done. It is altogether different to ask them to give a witness statement. Whilst it is theoretically possible to compel such a witness to come to trial, it is very difficult to build a claim on the basis of what a witness might say at court if summoned to give evidence. HMRC is a potential repository of information about the company, insofar as the company's non-compliance in making returns or paying tax on time is a feature of the company's failure and leads to communications between the company and HMRC recorded in its history notes and emails. But in practice, HMRC's history notes tend to be of limited probative value, save where there has been an extensive HMRC investigation. Sometimes the liquidator tries to shortcut the process of producing evidence by referring to a decision in other proceedings, such as a decision in the tax tribunal, or the fact that a director has given a director's disqualification undertaking. The problem is that whilst the court might allow mention of those matters within the liquidator's recovery action as evidence of their existence, the content cannot be relied on as evidence in the recovery action. There are a series of cases about that, and I would just refer to the cases of Ward against Saville in 2021, and more recently the case of Mobigo Limited against McAteer. When giving a disqualification undertaking, the director expressly does not oppose the allegations of unfitness and only for the purposes of the disqualification. In other words, the director does not admit the facts. Another developing area of law concerns the giving of opinion evidence. Historically, liquidators have felt comfortable giving opinions as a result of their qualification and experience as insolvency practitioners. The problem is that they can never give expert evidence in accordance with CPR Part 35 because they are not independent and they have a financial interest in the outcome of the claim. Irrespective of Practice Direction 57AC, the courts are clamping down on this. One key area relates to proving that the company was insolvent when a particular event happened. Another relates to opining that a company had insufficient distributable profits to justify an interim dividend. Yet another relates to the quantification of loss flowing from the director's breach of duty. In that respect, see the recent case of Wesley and White, where the court said the liquidator's attempt to calculate the loss was a matter for an expert witness and the evidence was disallowed. That is the evidence from the liquidator's position. Now look at it from the director's position. Not only can the director exploit the liquidator's lack of knowledge and the mistakes made in the presentation of the liquidator's evidence, but also the director has the advantage of having been there at the time of the relevant events. Historically, the company's records would be in paper form and delivered to the liquidator, making it hard for the director to access evidence to respond to the claim. But nowadays, it is more likely that the director will have access to the accounting records, or rather a copy of them, to email accounts from which he and others sent and received emails relating to the business, and also will have electronic copies of other key documents. The director will also know which other people worked in the business who might be prepared to give corroborative evidence. If such a witness writes to the director setting out what happened, then that will have an effect on the proceedings because, so far as the liquidator is concerned, the potential exists for that witness to give a witness statement later on or to be summoned to trial. So, in conclusion, the director is a much better position to be able to give evidence nowadays. I next turn to identifying when the onus of proof is on the director. There is a general misconception that in claims against directors, the burden of proof is on the director to explain what happened and to demonstrate that what happened was done honestly for the proper purposes of the company and that the director was not negligent. But as a starting point, the burden of proof is on the liquidator or the company if the company is the claimant, which is the same as the default position in all civil recovery actions. And in that respect, I again refer to the case of Wesley and White from 2018. In relation to breach of fiduciary duty claims against the director, in 2019, the High Court reconciled 150 years of conflicting authorities by deciding that liability for breach is fault-based. That was the trial decision in Bernard Holdings against Fielding, not the Supreme Court decision. The case concerned a dividend that the court found to be unlawful. The court said that if the directors knew of the facts that made it unlawful at the time, then they would be liable. But if they did not know, then they were not liable so long as they had taken reasonable care to secure the preparation of accounts which showed the dividend could be paid, even if it subsequently emerged the accounts were wrong. In Wesley and White, the court was concerned with the entry into deeds of release, which the director understood to be a constituent part of an novation of contracts by the company, which was in financial difficulty. The liquidator brought a breach of duty claim under Section 172 of the Companies Act in 2006, alleging that the director had failed to have sufficient regard to the interests of creditors when entering the deeds. The court said there was an objective test as to whether the creditor's interests had been considered, which was satisfied, but that after that the test was subjective, namely whether the director had honestly believed he had acted in the best interest of creditors. I would also refer to the recent High Court decision in Aston Risk and Management against Jones, where the court reviewed the nature of the duty under Section 172 Companies Act, as explained in the recent Supreme Court decision of BTI and Sequana. Accounting records can only take a liquidator so far. Entries in the company's accounts are just a piece of evidence. They are not in any way conclusive and binding evidence on the director. In addition, the fact that an accounting entry records something as happening on a particular date does not mean it did happen on that date. In that respect, I would refer to the decision in Manolay Partners against Rutter in 2022. In contrast, the absence of accounting records can be a problem for the director. In the decision of Hunt and Majid from 2020, the directors asked the court to give them the benefit of the doubt that payments were lawfully made in the absence of adequate accounting records caused by their failure to keep decent records in the first place. The court followed the reasoning in an earlier Court of Appeal decision in Mumtaz Properties, which said, "In my judgment, contemporaneous written documentation is of the very greatest importance in assessing credibility. Moreover, it can be significant not only where it's present and the oral evidence can then be checked against it, it can also be significant if written documentation is absent. For instance, if the judge is satisfied that certain contemporaneous documentation is likely to have existed were the oral evidence correct, and that the party adducing oral evidence is responsible for its non-production, then the documentation may be conspicuous by its absence, and the judge may be able to draw inferences from its absence." And then later in the judgment, the court said, "Put another way, it was not open to the respondents to the proceedings in the circumstances of this case to escape liability by asserting that if the books and papers or other evidence had been available, they would have shown that they were not liable in the amount claimed by the liquidator. Moreover, persons who have conducted the affairs of limited companies with a high degree of informality, as in this case, cannot seek to avoid liability or to be judged by some lower standard than that which applies to other directors simply because the necessary documentation is not available." If a director has benefited from a transaction with a company, then the usual burden of proof is qualified. In the case of Reeve from 2011, the High Court said, "I am satisfied that whether it's to be viewed strictly as a shifting of the evidential burden or simply as an example of the well-settled principle that a fiduciary is obliged to account for his dealings with a trust estate, that counsel for the liquidator is correct to say that once the liquidator proves the relevant payment has been made, the evidential burden is on the respondents to explain the transactions in question. Depending on the other evidence, it may be that the absence of a satisfactory explanation drives the court to conclude that there was no proper justification for the payment. However, it seems to me to be a step too far for counsel to say that absent such an explanation in all cases the default position is liability for the respondent directors. In some cases, despite the absence of any adequate explanation, it may be clear from other evidence that the payment was one which was made in good faith and for proper purposes. The decision in Edessa was followed in the case of GHLM Trading against Maru in 2012, where the High Court said, "In the circumstances, I agree with counsel for the liquidator that once it is shown that a company director has received company money, it is for him to show that the payment was proper. In a similar way, it seems to me that where debit entries have correctly been made to a director's loan account, it must be incumbent on the director to justify credit entries on the account. That conclusion makes the more sense when it's remembered that the director, A, will have been one of those responsible for the management of the company's business, and B, will have had a responsibility for ensuring the proper accounting records were kept." In the context of a wrongful trading claim under Section 214 Insolvency Act, there is a specific reversal of the burden of proof under Section 214 subsection 3, where the liquidator has proved that the company was insolvent and that the director knew or ought to have concluded that there was no reasonable prospect that the company would avoid going into insolvent liquidation. In that situation, it is up to the director to prove that he took every step with a view to minimizing the potential loss to the company's creditors as he ought to have taken. In the context of a transaction at an undervalue claim under Section 238 of the Insolvency Act, there is a presumption of insolvency in relation to any transaction at an undervalue which is entered into by a company with a person who is connected with the company. In the context of a preference claim under Section 239, there is a presumption of a desire to prefer, where a company has given a preference to a person connected with the company, but there is no presumption of insolvency. Finally, before looking at the case study, I consider the position of overcomplicated claims. One common feature and criticism I have of liquidators' claims is that they are unnecessarily complicated in three particular ways. Firstly, a number of different claims are bundled together in a manner that simply does not make commercial sense, especially where some of the claims are for comparatively insignificant amounts, or the amounts of the claims in aggregate exceed the director's ability to pay. Secondly, instead of confining the claims to relatively straightforward transaction at undervalue or preference or Section 423 or breach of duty claims, the case is expanded to make allegations of dishonesty, such as dishonest receipt or assistance, or unlawful means conspiracy, or fraudulent breach of trust. Or a wrongful trading claim is apparently included as some sort of backup claim. Thirdly, claims are made against a number of directors, apparently without sufficient investigation as to the responsibilities of each, or proper consideration of who is a financially viable target to make a recovery for creditors. A consequence of this is that there are deficiencies in the way the claims are put, or claims are taken against the wrong people. An illustration of this is a case called IT Protect, where on the face of it, the liquidator successfully obtained judgment for about £118,000 against the director who had abrogated his responsibilities by not having any involvement in the company and letting two other people run it. Subsequently, a barrister's chambers published an article about the cost consequences of that case. Whilst the liquidator had succeeded against the first respondent, the claim against the second respondent, represented by the same legal team, was lost. Presumably, the liquidator had to pay the second respondent's costs, but as a result of over-pleading the case, the court only allowed the liquidator to recover half his costs from the first respondent. The amount of costs involved were not revealed, but clearly had a detrimental effect on the net recovery. The liquidator's final liquidation report noted a recovery of £8,000. Another recent example involves the non-insolvency case of von Westenholt against Gregson from 2022, where the claimant succeeded at trial. The claimants asked for an indemnity cost order on the basis that the defendants had refused to mediate. The court said refusal to mediate can be justified especially where there are allegations of dishonesty. The court then reduced the costs which the claimant could recover by 25% because it had overpleaded the case, making allegations of dishonesty which were not successful at trial. From the perspective of a director defending such a claim, there is a difficult decision to make. If the liquidator is using the summary procedure, the most obvious route is to ask the court to direct that the case be pleaded by way of points of claim and defence, and then to follow the route applicable to a Part 7 claim involving full disclosure and witness statements. Again, by way of illustration, I was involved in an unreported case 2 years ago where a liquidator issued breach of duty proceedings using the summary procedure for over £3 million. We applied to court to direct pleadings and an order was made. The liquidator then issued a Part 36 offer for less than 5% of the claim value, where the 21-day period for acceptance expired before the date he was due to serve points of claim. The offer was so low that our client director accepted to bring matters to an end. I inferred from what happened that when the liquidator was forced to particularise the claim, he couldn't. If the claim has been brought under Part 7, then you have to consider applications to strike out parts of the claim or making requests for information. Usually such steps are beyond the budget of the director, which means they have to follow Plan B, which is to defend the proceedings the best they can until the liquidator wakes up to the fact that parts of the claim are seriously flawed. Overcomplicating the proceedings can be a nightmare for the liquidator if ATE cover has been arranged, and then it looks like some of the claims will not succeed, or the liquidator will lose against one or more of several defendants. It also ramps up the costs being incurred by all parties and makes it very difficult to settle the claims, as illustrated in the von Westenholz case I referred to earlier. From my perspective, one consequence of this is that the liquidator and lawyers get lost in working out which claims are good and which are not, which means that simple good claims are overlooked or simply not evidenced. I now turn to the case study and how I might advise Freya and Frank. So first of all, let's look at defending the claims against Freya. We start with the £42,000 paid to Audi. The liquidator may have a claim against Freya in respect of this payment, but it's complicated. I will leave the issues arising from that payment to the complementary talk by Tanya Clench. As regards the £900,000 dividend, the first question to ask is whether the company was solvent at the date this dividend was declared. Whilst the case study says it was declared on 31st October 2020, it is also necessary to explore whether the declaration was earlier and recorded in the accounts later. For example, supposing there is an email exchange with the company's accountant in June 2020 saying Freya has spoken with Frank and agreed to declare a dividend to offset a loan account and to avoid the company being landed with a Section 455 tax charge. If the company was solvent at the relevant date, the next question to ask is what financial information was available to Freya to assess whether the company had sufficient distributable profits to support the payment of the dividend. There is no requirement for that financial information to be within a single accounting document. On that, see the decision in Burden Holdings against Fielding. The question is whether it could be discerned from the available information that there were sufficient profits. If the information was available and showed sufficient distributable profits, then Freya's executive role in the business would mean she is on top of the numbers, and I would expect her to be able to confirm to me she was aware of what they said. The next question is whether she obtained Frank's agreement to the declaration on the basis that they believe there was sufficient distributable profits. No formality is required in that respect. This would provide a sufficient explanation in the pre-action phase to demonstrate the dividend was a valid interim dividend. In relation to the £100,000 credit against the overdrawn director's loan account, the director's loan account is the ledger where credits and debits are recorded, and it's perfectly acceptable to enter credits for company liabilities that Freya has personally paid. As regards the £15,000 spent on expenses, it will initially be for Freya to give details of those expenses to demonstrate the credit was justified. What happens next will depend on what she produces. As regards the £15,000 spent on paying company invoices, it should be clear from the company's records whether the suppliers were entered and marked as paid. What happens next turns on the outcome of that review. As regards the £40,000, I would expect Freya to say the connected company would only supply on these terms. Assuming Freya is also a director of a connected company, one cannot ignore the duties she owed to that company. The £100,000 credit entry may have been made 23 months before the winding up petition was presented, but the actual cash payment by Freya is likely to have been made before that, meaning it was beyond 2 years before the commencement of liquidation, so that consideration of a preference claim will not arise. But even if it did, Freya will say the payment was to ensure continuation of supply and was not influenced by a desire to prefer, as evidenced by the fact that only part of the debt was repaid. As regards the £30,000, I would expect Freya to explain what the invoice was for, was it goods or services, when they were requested, when they were supplied, and what discussions were had with the supplier about payments. For example, the invoice may have been issued before delivery. If this was a potential preference, whether the supplier was connected goes to the question of whether there is a presumption of a desire to prefer, but that is very much secondary to the question of what happened. Turning to defending the claims against Frank, as an obvious starting point, Frank would need to be separately advised from Freya. There is no problem with Frank being a non-executive director, but that role does require him to keep himself informed as to the company's financial situation. If the company produced quarterly management accounts, which he reviewed, as per his stated role, then the question of whether any claims might lie against him would depend on whether any claims against Freya are capable of being pursued and to what extent Frank knew about them and either approved them or failed to take steps to prevent them. It might suit his defence to point the finger at Freya. But if Frank ceased to review the accounts from March 2021 onwards, then irrespective of salary, he has the responsibilities of a director and would be open to allegations that he has abrogated his responsibilities as a director. That would expose him to potential claims under Section 174 of the Companies Act for acting in a manner no reasonable director would. As regards Frank's mental health issue, the Insolvency Practitioners Association has published guidance on the adaptations that office holders should consider. Applying to court for an order for examination is the wrong thing to do. The liquidator would be duty-bound under the Civil Procedure Rules and Practice Direction 1A to notify the court of Frank's depression, and in turn the court is required to convene an initial hearing to consider what adaptations should be made. The chief ICC judge has issued internal guidance to the judges, drawing their attention to the requirements of Practice Direction 1A. Regarding the bi-monthly drawings, initially of £2,500, increasing to £5,000 in the period from April 2021 to February 2023, and recorded in the company's accounts as drawings, Freya is clearly in difficulty. She cannot justify those payments as remuneration because her established remuneration structure consisted of basic salary and dividends. She cannot argue that she's entitled to additional remuneration on the basis that the true value of her services justified a higher salary. In that regard, I'd refer to the recent cases of Bronya Buchanan Associates in 2022 and then Barton against Gwyn Jones in 2023. Despite the relative informality that applies to the declaration and payment of interim dividends, it seems unlikely that she could argue that any of these payments were lawfully declared interim dividends, misdescribed by the bookkeeper's drawings, because it is doubtful that the company would have had sufficient distributable profits to support such dividends, bearing in mind the financial pressures it was under at the time. And that brings me to the end of my talk. In conclusion, I would say that the liquidator has a choice whether to take civil recovery proceedings against a director, but the director has no choice. If the liquidator is claiming more than the director can realistically afford to pay, then settlement is not an option for the director. A liquidator who brings realistic claims, who keeps the claim simple, and who deploys an early Part 36 or call-to-bank offer is far more likely to persuade a director to settle and produce a return for creditors.